5 seconds to go. Start. From the record of the case, it is evident that several letters have been written and or applications have been made by the petitioner making grievances about the threats administered to him and his family by the accomplices of the accused. However, it is an admitted position that no action is taken either by the SSP Allahabad or by government of Uttar Pradesh either to afford protection to the petitioner and his family or to thwart such threats made by the accused and or their accomplices. It is relevant to notice that it was claimed by the prosecution that the driver of the deceased was an eyewitness, and it is the case of the petitioner that due to threats he turned hostile. The fact that the driver had turned hostile is not in dispute. The fact that in spite of the receipt of several summons, neither the petitioner nor his wife nor his family members nor other witnesses have been able to go to Haridwar to depose before the court is not denied by the state government. Therefore, this court is inclined to accept the case of the petitioner that he and other witnesses have not been able to respond the summons only because of fear to their lives due to the threats administered by the accomplices of the accused. There is no manner of doubt that because of chasing of the petitioner and his relatives by the accomplices of the accused, they have not been able to attend the court and tender evidence. If this situation continues, then the prosecution would not be able to lead any evidence in such a brutal murder case, and the accused will have to be acquitted. The record indicates that 4 accused have been already enlarged on bail, but neither the police nor the state agency has taken any steps for the purpose of getting their bail order cancelled. Above judgment clearly enunciates the importance of witness in criminal trial. This is a case of murder of a superintending engineer. There is no manner of doubt that brutal assault was mounted on him, which resulted into his death. The son of the deceased is seeking transfer of proceedings on the ground of coercion and threat to the witness as well as doubtful sincerity of the investigating agency and prosecuting agency. Ineffective cross examination by public prosecutor of the driver who resiled from the statement made during investigation speaks volumes about the sincerity, effectiveness of the prosecuting agency. The necessity of fair trial hardly needs emphasis. The state has a definite role to play in protecting the witnesses to start with, at least in sensitive cases, the learned judge has failed to take participatory role in the trial. He was not expected to act like a mere tape recorder to record whatever has been stated by the witnesses. Section 311 of the Code and Section 165 of the Evidence Act confers vast and wide powers on court to elicit all necessary materials by playing an active role in the evidence collecting process. Stop.